corporate attorney. I don't know anything about domestic violence. What do I do now?
Pro bono work is vital to our court system. One of the most cherished protections citizens have is the constitutional right to be represented by counsel. We as lawyers are privileged to be able to perform that vital role in our system of justice. We also have an obligation to help those in need who cannot afford to retain counsel. That said, when attorneys are assigned a pro bono case in an area outside their expertise, that can present a challenge. For that reason, we've created a manual to help navigate the process. The manual and this video are meant to help you provide competent counsel to your client. We also encourage you to speak with colleagues, friends, and other attorneys who frequently deal with this type of work, and to contact the pro bono coordinator in your vicinage to better understand the process. Pro bono work is not just a critical component of our justice system, it also enables us to gain valuable experience and learn about new substantive areas of the law by representing indigent defendants who are entitled to counsel. In other words, pro bono assistance can foster professional development. At the same time, it allows us to perform a critical public service. We thank you for your service.
The law requires all attorneys licensed in New Jersey to represent indigent defendants without pay where the legislature has made no provision for the public defender to represent those defendants. These are commonly referred to as pro bono assignments. When the vicinage pro bono coordinator gets a request to assign an attorney for a pro bono case, they check the Madden v. Delran computer list and assign the case to the next eligible attorney. The list is alphabetical by last name. It is filtered by the number of pro bono cases previously assigned. The coordinator has no control over choosing an attorney. Attorneys can be assigned to represent defendants for municipal court appeals, parole revocation hearings, or in this case, domestic violence contempt.
In a domestic violence contempt case, the defendant is charged with violating a court order not to have any contact with the victim. This could be violating a temporary restraining order, a TRO, or a final restraining order, an FRO.
The complaint or warrant containing the contempt charge will usually contain a bail condition prohibiting the defendant from having any contact with the victim. This is independent of any no-contact provisions in a TRO or FRO. The no-contact bail provision will remain in effect even if the underlying restraining order is dismissed. Now that you have been assigned to a case, the first thing to do is get a copy of the charges against your client. You will find your client's charges listed on the complaint CDR2 form forwarded to you with the assignment. If you need more information, contact the Family Division of the court in which your case was filed. The contact information will be on the form you received with your assignment. Next, you should contact your client whose address is listed on the complaint. In the event the address listed is incorrect, you can contact the Family Division of the court in which the case was filed to get updated information. There are times when your client may be incarcerated. If the defendant is in jail, you will need to make arrangements to meet with your client at the county facility.
Mr. Roberts, you have a domestic violence case against you where you violated a restraining order November 3rd, 2011.
Well, yeah, I mean, it wasn't really domestic violence. I didn't even see her.
You should discuss the case with your client, including the nature of the charges, possible defense, and all options. While it is preferable this meeting take place before the court date, it is common for it to take place at the first court hearing. After you contact your client, you should request discovery from the county prosecutor assigned to the case. Discovery materials can include the complaint, CDR2, temporary or final restraining order, police reports and witness statements, affidavit of probable cause, defendant's criminal history, any other records which may play a part, like cell phone records, email, or text messages. A list of materials to which a defendant is entitled is included in R3:13-3. Your assignment paperwork will list the upcoming court date. The case will be heard in the family part of Superior Court by the designated judge. Your first court appearance will be a plea conference. This may be where you meet with your client for the first time. If you haven't received discovery materials by the plea conference, the prosecutor should provide them at that time.
Okay.
Just have some additional discovery that I need to give to you.
All right. Thank you.
If you have not already met with your client, you should review the case with your client and then meet with the prosecutor.
Okay, Jake, do you know why you're here?
Yeah, she called the cops on me.
Okay, well, this is your second violation of the restraining order. So it's pretty severe. They have some serious evidence in reference to telephone records and a card.
I sent her a card.
Okay, but
I called on the phone.
okay. All right, well, I'm going to go talk with the prosecutor, see what can be done, okay?
Prosecutors will usually make a plea offer in order to resolve the case. The prosecutor is obligated to discuss any plea offer with the victim.
This offense with this matter.
Well, it's his second violation, so he's facing 30 days of jail.
Discuss this plea offer with your client in private.
Okay, Jake. Spoke with the prosecutor. 30 days jail is mandatory.
30 days I gotta do? That's the best you could do?
30 days is mandatory. That's the best. Basically, the plea agreement is that we can do 30 days weekends. That way you can still go to your job Monday through Friday, and it will not be any interruption.
All right.
If the client refuses the plea offer, you should advise the prosecutor. If this is a first offense, the prosecutor will typically offer a plea of probation. But depending upon actual facts in the case, the prosecutor may insist on jail time, which could include time already served. The court may impose jail time for a first contempt offense if the aggravating circumstances outweigh the mitigating. If this offense is a second or subsequent conviction of domestic violence contempt, there is a mandatory 30-day jail term. If you cannot agree on a plea, then the court will set a trial date. As assigned counsel, you will handle the trial.
Friday.
If your client accepts the plea agreement, both sides will appear before the judge.
Aye.
Hi, good afternoon, everyone. This is the matter of the state of New Jersey versus Jake Roberts. It's docket FO 03476212. Counsel, can I have your appearance for the record?
Good morning, Your Honor. Rima Hindawi Scarmello on behalf of the state.
Good morning.
Good morning, Your Honor. Hashim Chip Thomas on behalf of Jake Roberts.
All right, good morning, everyone. You can all be seated. Ms. Scarmello, I'll hear from you first.
Yes, Your Honor. We're here. This is the defendant's second violation. We have reached a negotiated plea, which the defendant has agreed to accept. The terms and condition of that plea is that the defendant is to serve 30 days jail because this is a second violation, as well as all mandatory fines and penalties, which would include the $75 Safe Streets, as well as the $50 VCCB. And also, the state has no objection to this defendant serving his jail time on the weekends based on the representation that he is employed full-time.
Now I ask that you stand, raise your right hand, state your name for the record.
Jake Roberts.
Do you swear or affirm that the testimony you're about to give the court shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you, Mr. Roberts. You can be seated. Mr. Roberts, you have in front of you a plea form. Have you seen that form before?
Yes, I did, Your Honor.
All right. And did you read it?
Yes, I did.
Do you understand it?
Yes, I do.
Did you have sufficient time to consult with your attorney regarding the terms of the agreement?
Yes, I did.
And the agreement calls for a plea of guilty to a violation of the restraining order. Do you understand that?
Yes, I do.
And you understand it's the second violation of the restraining order. Do you understand that?
Yes, I do.
And that carries a mandatory 30 days in jail. Do you understand that?
Yes, I do.
And are you accepting the offer of the state for 30 days to be served on weekends, along with the mandatory fines and penalties?
Yes, I do.
Now, you understand, Mr. Roberts, that you do not have to accept the state's offer, that you have a right to trial. Do you understand that?
Yes, I do.
And at trial, you are presumed innocent, and it's the state's burden to prove, beyond a reasonable doubt, the allegations against you. Do you understand that?
Yes, I do.
And you also understand that at trial, you have a right to cross-examine the state's witnesses and to subpoena your own witnesses. Do you understand that?
Yes, I do.
And you also have the right to remain silent, or you can testify on your own behalf. Do you understand that?
Yes, I do.
And are you waiving your right to trial in this matter?
Yes, I am.
Now, are you doing this freely and voluntarily without any coercion or duress?
Yes, I am.
Has anyone put any pressure on you or offered you anything to accept this offer?
No, they have not.
And are you operating today under the influence of any drugs or alcohol, any medication, or any medical condition which would prevent you from understanding what you're doing here today?
No, I'm not.
Now, you are represented by legal counsel, is that correct?
Yes, I am.
And have you had an opportunity to discuss this plea with your attorney?
Yes, I have.
Do you feel you need any additional time to discuss this plea with your attorney?
No, I don't.
And are you satisfied with your attorney's representation in this matter?
Yes, I am.
And do you have any questions of the court?
No, I do not.
Now, you understand that in order for the court to accept your plea, you must give up your right to remain silent, and you must tell me exactly what you did that makes you guilty of the offense. Do you understand that?
Yes, I do.
So in other words, you're going to have to give me a factual basis for the guilty plea. All right?
Okay.
All right, Mr. Thomas, if you would at this time question Mr. Roberts as to the factual basis for the plea.
Yes, Your Honor. Mr. Roberts, on March 19th, 2012, were you aware that there was a final restraining order against you?
Yes, I was.
Do you understand that you were not to have any contact with the victim in any way?
Yes, I was.
On March 21st, 2012, did you have contact with the victim?
Yes, I did.
And did you understand in having contact with the victim, you violated the restraining order?
Yes, I do.
And in what ways did you have contact with the victim on that date?
I called to wish her a happy birthday. I left a voicemail on her answering machine, and I sent her a birthday card.
Your Honor, I submit the factual basis if that satisfies the court.
It does. Thank you, Mr. Thomas.
Thank you, Your Honor.
Anything else from the state's perspective before I make my findings?
No, Your Honor.
Anything else from the defendant?
No, Your Honor.
All right, thank you both. I've heard the testimony of the defendant with regard to the factual basis and the arguments of counsel.
The judge will then ask if you would like to be heard before sentencing.
I find that he's had sufficient time to discuss.
You can request that any fines be paid over the period of probation.
I find that this defendant understands the terms of
The court may also ask the defendant if he would like to say anything before sentencing.
He's got a right to trial, and it was the state's burden at trial.
Generally, the court will follow the plea agreement and discharge bail if it was posted by the defendant.
Mr. Roberts, having accepted your guilty plea and finding that there's an adequate factual basis, I now will sentence you in accordance with the state's recommendation. Mr. Roberts, you will be sentenced to a term of 30 days in jail, as it is a second offense and a mandatory jail requirement of 30 days. I will allow you to serve the 30 days on the weekends in light of your work situation. I will also have to charge a $75 Safe Streets violation, as well as a $50 VCC penalty. Mr. Roberts, I have accepted your guilty plea. I want to advise you of your appeal rights. You have 45 days from today to appeal your conviction and sentence. If you cannot afford an attorney, counsel may be appointed to represent you in your appeal. If you miss the 45-day deadline, you can ask for a 30-day extension to file your appeal if you can show good reason for missing the deadline. If you miss the extended deadline, you may lose your right to appeal. Do you have any questions for me about your right to appeal, sir?
No, I don't.
And did you discuss the appeal rights form with your attorney?
Yes, I did.
And did you sign the appeals right form?
Yes, I did.
Thank you, Mr. Roberts.
You and the defendant will sign an appeals rights form. If your client is sentenced to probation, he should report to the probation division.
Form and clearly understands his rights with respect to appeal. Thank you, Mr. Roberts.
If your client rejects the plea bargain, you and the prosecutor will complete a trial memorandum outlining potential witnesses. Then the parties will go before the judge and defendant will be placed under oath. The prosecutor will outline the plea offer to the court. The judge will question the defendant about his understanding of the plea offer. The judge will also explain to defendant the consequences of rejecting the plea and will tell him the maximum penalties that are possible if defendant is convicted. Bail will be continued, and if there is a restraining order still in place, defendant will be reminded to abide by that order. Then the court will set a trial date for everyone to come back.
FO 03476212 is the state.
Sometimes the prosecutor may want to dismiss the case at the plea conference.
On behalf of the state, just wanted to advise you that this is the second listing of this matter. The victim has not appeared. Our office has made numerous phone calls. We've reached out to her.
This may happen when there is no proof the defendant knew of the restraining order or when the victim refuses to cooperate with the prosecution.
Thank you, Your Honor.
If this occurs, the parties will appear in court and the prosecutor will place the reasons for the dismissal on the record. If the court accepts the dismissal, the defendant's bail will be discharged. The court will remind the defendant to abide by the restraining order if it still exists.
For lack of prosecution at this time. Thank you, Mr. Roberts.
Thank
I'll
you.
also order that any bail that has been taken from Mr. Roberts has been submitted be returned to the surety. Thank you.
Once a
Thank you.
case is completed, the court will notify the Finance Division to discharge the bail. The Finance Division is available to assist with any questions. The sentencing range is up to 180 days in jail, fines up to $1,000, VCCO assessment of $50, Safe Neighborhoods assessment $75, probation domestic violence surcharge of $100. Any person convicted of a second or subsequent non-indictable domestic violence offense must serve a minimum jail term of not less than 30 days. Most cases are settled before going to trial. If your case goes to trial, it will be a bench trial, which means there is no jury. Both the prosecutor and defense counsel will make opening statements. The prosecutor will call the state's witnesses, and you will be allowed to cross-examine those witnesses. At the end of the state's case, you may make a motion to dismiss if there is insufficient evidence to support a finding of guilt. If the motion is granted, the case is dismissed. If the motion is denied, you should call your first witness. The prosecution will be allowed to cross-examine your witnesses. Under the Fifth Amendment, the defendant has the right to remain silent, so your client does not need to testify at trial. The state must prove beyond a reasonable doubt the defendant knowingly violated the restraining order. After all defense witnesses are heard, you will make a closing argument, followed by the prosecutor's closing argument.
Concrete testimony stating any type of...
The court may give its decision from the bench, or if the case is more complex, the judge may reserve judgment and prepare a written decision.
Counsel, I make the following findings. I do accept the plaintiff's.
If the defendant is convicted and wishes to appeal, you are required to file a notice of appeal. You should speak with the Pro Bono coordinator about whether you will be responsible for handling the appeal. Defending a domestic violence contempt case, a primer for assigned counsel, is available at the judiciary website.